That brings to item 3, House Bill 2806 by Chairman Halsey. You've got a motion and a second, sir.
Thank you, Mr. Chairman. Thank you, committee. There's an amendment on this bill if you want to stick it on there. Or do you want me to tell you what it's about?
Just go ahead and tell us what it's about, sir, and we'll just kind of
This
go.
deals with the UCC code, the changes that went into 1994. It's just come to light in the last couple of years that the way they do business is different than what most folks understand or perceive. Most people think they buy stock and you have an investment in stock and you own that, and you do as far as the broker part goes. As soon as it moves up line, it goes into a big pool, and then it's used as collateral on loans. And what happens if there's a collapse up there, a bankruptcy, the bank that made the loan is the first in line to get the worth of your stock and your property. What this bill does is two things. It says if you have to file a lawsuit to get your money back, you can do it in the state of Tennessee. And the second thing it does, it changes the order of importance on who gets the money first. And it puts Tennessee people who have investments to be the first in line to get their money back instead of the banks. That's what the bill does.
And thank you, Chairman Halsey. Appreciate you bringing this bill. I know we had, it was scheduled, we had 2 opportunities in subcommittee to hear from expert witnesses on both sides. We appreciate all those folks coming to testify in front of the committee. Had opportunity to meet with those. Several of us met with those folks in our offices in between meetings from subcommittee and in between now, and appreciate all the information and education that we got from your folks, and very, very pleasant, very well informed, smart people, to say the least. With that said, I have Representative Bolso. You're recognized.
Thank you, Mr. Chairman. If I might inquire, will there be testimony here today?
We're at the will of this committee. So, if that's what we want to move forward with,
Yeah, it's a complicated issue, and if there were witnesses present that we could question before we disposed of the bill, I would appreciate that.
Okay. All right, members. Any objection to going out of? Let's back up. Chairman Halsey, you do have House Amendment 14435.
That is correct.
You got a motion and a second. Members, we want to go ahead. Does that rewrite this bill?
That's correct.
Okay, members, you want to go ahead and get this on this bill so everybody's on the same page? Without objection, all those in favor of adopting House Amendment 14435 say aye. Aye. All opposed say no. Ayes have it. Now we're back on the bill as amended. And without objection, we're going to go out of session and hear from Stephen Sepinick and Tim Amos. Sir, if y'all come here and take a seat, you each have 3 minutes apiece, or excuse me, 3 minutes collectively to state your positions. I know, Mr. Amos, you've been here, and Mr. Sepinick has not. So if you want to be sure your red light's on, and we'll go from there, and we'll begin once you start speaking. Thank you. We'll have unlimited time for questions.
Thank you, Mr. Chairman, members of the committee. Tim Amos. I'm an attorney, and I'm one of the 5 state-appointed uniform law commissioners for Tennessee, and I represent the Uniform Law Commission. This legislation would be detrimental to the state in a number of ways. It is overly simplistic to say that we're going to give Tennesseans additional rights. In fact, I think you're taking away some of the rights by changing the jurisdiction for the location of the situs of a transaction. You disadvantage people like First Tennessee or First Horizon, Alliance Bernstein, who have their headquarters here. So that rather than relying on the law of the state, which hopefully would be uniform, they now have to rely on the law of 50 different states where every single one of their customers, which is a compliance problem, and it adds additional expense. So that's the first problem. The second problem is the bill removes exemptions, as he says, flips the priority. The 2 priorities that it removes is, one, the first one is the ability of a consumer to use margin accounts. Basically says consumer always has priority. And so it takes away the consumer's ability. That's a detriment to have a margin account. Secondly, it takes away the consumer's ability to engage in what are called short sales. where they loan their stock to someone else, and they agree that if it's sold in that process, they get a fee, which enhances their income, and secondly, they get a guaranteed price for their stock. So it takes away flexibility in consumers' ability to manage their accounts, and thirdly, and even more detrimentally, it changes the priority for securities intermediaries that are changing and trading securities on a daily basis, which would have a significant disruption in the financial markets as those people operate in Tennessee. So for all those reasons, we think it's a terrible bill, and we would hope that you would defeat it or defer it.
And thank you for your candor. Mr. Sepanik?
Yes, my name is Stephen Sepanik.
Hey, be sure your red light's on there, sir. Thank you.
My name is Stephen Sepanik. I'm an adjunct professor at Vanderbilt Law School and a resident of Nashville. I have been teaching and writing about the Uniform Commercial Code for more than 30 years, and I'm here today at the request of the Uniform Law Commission, but my comments are my own. This is a well-intentioned bill addressing a non-existent problem, and does so in a way that is likely to cause significant damage to commercial transactions and to Tennesseans. I have 3 points. First, the priority granted to secured creditors of a securities intermediary under Section 8511 applies in a narrow circumstance, only if the secured creditor has what's called control of the underlying securities or securities entitlements, essentially to someone higher up in the indirect holding system. It is designed to ensure that the failure of one intermediary does not cause a cascading effect of failures of multiple intermediaries and lead to large-scale financial collapse. The rule is critical to the indirect holding system, which makes securities trading possible in the electronic age. Eliminating it would be very dangerous. It is also unnecessary because the concern underlying this bill is unfounded. Customers of intermediaries are fully protected by other law. Specifically, securities intermediaries are regulated, audited, and insured. Regulations prohibit them from using customer securities and entitlements for this, as collateral for the securities intermediaries' own debts. So the concern here simply does not apply. It would be a criminal act for them to do what is alleged to be the problem. The audits ensure that they do not violate these rules, and the insurance protects customers in the event that somehow an intermediary violated these rules and the audits didn't discover it. Collectively, these protections have been effective, although some securities intermediaries have failed since Article 8 was revised in 1994. No customer has ever lost out due to the rules of Section 8511. Finally, Sections 1 and 5 of this bill would change the law that governs the relationship between a securities intermediary and its customer, and the law that governs perfection and priority of a security interest in a securities account or entitlement. Doing that would potentially be disastrous for Tennesseans. These rules give assurance that regardless of where litigation occurs, every state will look to the same state's law to determine the rights of the parties. Choice of law rules may seem innocuous, but they are among the most essential rules in the entire UCC. They minimize risk associated with transactions and obviate the need for contracting parties to investigate the law of every state or perhaps country before entering into a transaction. Changing these rules would impel commercial parties to cease doing business in Tennessee or with Tennessee residents. That is in no one's interest. Thank you.
And thank you for that explanation. Members, I have Representative Lambert, or excuse me, Leader Lambert on the list. You're recognized, sir.
Thank you, and I respect both of you gentlemen. I've listened to testimony. I've looked into this issue at length over the last few weeks, and I guess I'm a little more intrigued than probably y'all would like us to be. There's lots of property interests that we secure in this state by state law. I mean, the same arguments that you are making on this have been made over and over again on why we can't, from a 10th Amendment standpoint, a states' rights standpoint, operate within a nation that has obviously kind of some overarching commerce rules that operate state to state, but at the same time provide a little more protection, a little more property rights protection, quite frankly, for citizens in Tennessee. So I'm not saying that I'm entirely there to the chairman's bill, but I think he's onto something a little bit more. And quite frankly, the pushback I've gotten from this leads me to believe that there may be a little something here that we could improve upon. And so I'm not saying this bill is perfect, and I appreciate y'all's testimony, but I just wanted to at least share my opinion, and please state whatever you'd like after I make this statement. But I think there are ways that we can improve and protect Tennesseans a little more than they're protected in other states. I'm not saying this bill's perfect. I'm not saying it's exactly the way to do it, but I've heard the other side of this, and I think there's ways that we can improve. Would y'all agree or disagree with that statement? And again, you've studied this for decades. We've had weeks, so to speak, on this particular bill, but that's just my statement on the issue, and then I want to hear from y'all.
Well, first of all, I would be happy to work with this committee or any members of the legislature and spend more time studying this in more detail. I personally, I have accounts with intermediaries. I think I'm fully protected under existing law. I don't think further protection is needed. But I'd like to respond by commenting about the process that the Uniform Law Commission uses to come up with legislation, which then states such as Tennessee have already enacted. I've been involved in numerous projects with the Uniform Law Commission over the years. Typically what happens is a study committee is appointed. It works for 1 to 3 years with representatives from all over the country. If they decide there's a problem, a drafting committee is appointed. It works for many years. I was very involved in the amendments to Article 9 of the Uniform Commercial Code in the 1990s. That drafting committee operated for 7 years with, again, outreach to pretty much everybody interested in the process. They try to decide things by consensus. They try never to have votes of the committee because that's usually a bad sign. And so they spend years developing something with the best minds in the world, not just the country, in the world, to make sure that it works. This law went through that process. It's been in effect for 30 years. If you want to change it, I would invite you to work with the Uniform Law Commission and benefit from their experience.
Any follow-up, Leader Lambert?
Thank you, Mr. Chairman, and sir, thank you for that. But in this particular state, at this particular time, I think you are looking at that study committee. I trust the members that were elected by their folks back home to come here and make these type of decisions. So I appreciate that offer of assistance, but these are the folks that I would recommend that y'all work with, because we have to vote and form the laws of this state as the voice of our district. So I appreciate that. Thank you for sharing that with us, but it would be best to probably try to work with these folks here. That'd just be my suggestion.
Very good. Next up, I have Representative Garrett.
Thank you, Mr. Chairman. Thank you all for being available. I've got a couple of questions, I think. One, the Uniform Commercial Code, can you just describe to me what that is, why the word uniform is in it, and then kind of give me some details of, because one thing that Representative Chairman Halsey did say that got my attention. You know, I've carried bills here so people that live in certain counties can sue in the county they're in instead of coming somewhere else, right? Mm-hmm. And the idea of a consumer that might be affected by the worry that he presents in his proposed legislation is they're going to have to go to New York or wherever to assert their rights, right? So I think that's the idea of being able to do that here where they live. And you both mentioned it in your opening remarks about why it's important that we have a uniform way of dealing with that, because then you've got to go out and research the different laws and states, and it complicates the matter of what are we asserting here. So I was wondering if you could just briefly describe what is the UCC, what's its important, and what does Tennessee do to conform to Article 9 of the Uniform Commercial Code?
Happy to, Representative. It's the Uniform Commercial Code is the joint product of the Uniform Law Commission, which is composed of representatives from every state, and the American Law Institute, which is a private nonprofit organization. Both the ULC and the ALI have been around for over 100 years, and they have partnered together to produce the Uniform Commercial Code. It was first drafted in the 1950s and received widespread enactment in the 1960s. It consists of, depending on how you count, because we have proposed recently a new article, but approximately 10 substantive articles. Articles 1, 2, 2A, 3, 4, 5, 6 has been repealed, 7, 8, 9, and now 12. It is state law because states enact it. It's uniform in the sense that hopefully states enact the same version, but states have enacted non-uniform. Every state makes slight changes to it to adjust to their own particular needs. And it governs a lot of commercial law. It is not regulatory in nature. It governs private transactions. So Article 2 governs sales of goods. Article 3 governs checks, promissory notes, checks. Articles 4, 4A govern the banking system, not in regulation, but in terms of how money transfers. Article 5 governs letters of credit. Article 7 governs documents of title. Those are really boring. You don't want me to talk about those. The most important are probably Articles 8 and 9. Article 8 governs investment securities, which is what this is here. It is not, again, regulation. It is not federal securities law, which governs the issuance of securities. This governs how securities are traded among private parties, and it facilitates that. It used to be, when it was first promulgated, that all securities were issued on paper, and trading became, the New York Stock Exchange was paralyzed by trying to accommodate trading on paper. And so Article 8 was amended to provide for electronic certificates, and then it was modified in 1994 to permit the indirect holding system, which is sort of what this legislation is about, that facilitates really the whole way in which securities are traded in the United States today. Article 9 deals with security interests in personal property, so basically when you use your car as a loan for collateral, or when you use securities as a loan for collateral.
Representative Garrett.
Thank you, Mr. Chairman. Thank you for that explanation, because sometimes we get lost in translation here. We have a lot of acronyms as it relates to some of the things that we address down here, so I appreciate that explanation. So the securities world is complicated already, right? Regulated heavily already with the UCC and others, right? It's a volatile, market, so to speak. You choose to enter into that, you hope to get some sort of return. So there's going to be a market risk, and I realize this legislation doesn't really pinpoint on market risk, but there's all kinds of factors that goes into how you trade stock now, especially since 1994, and it's all electronic. So my question: Can you provide an example that would be similar to this outside kind of the securities world that would apply, where if you have, or you're trading a good or a security, if you're trading something but you're giving it to somebody else to do that for a period of time, you still own that piece of equipment or good or whatever it is, and that person might have a security out there, some sort of collateral, some sort of inventory that could be subject to, if this third party you give your item to sell, that is subject to whatever their situation is, right? So there's a risk doing that. So I'm curious, outside the security world, what is a similar situation example where this may exist? And then what protections exist if there's a bankruptcy or something like that in that scenario versus what the consumer has now under the UCC? Could you elaborate on that for me, please?
I think I can, and I think the best example would be a consignment of goods. So let us imagine that I am a professional painter, and I paint portraits or landscapes. But I don't have a shop, and I want to sell my wares. And so I go to gallery, and I consign my paintings for the gallery to sell. Now, until the gallery sells them, I am the owner of the paintings. The gallery has zero property rights in the painting. But by consigning the goods to the gallery, I have authorized the gallery to transfer ownership to a buyer. And if the gallery, in fact, does transfer ownership to a buyer, then I'm entitled to my share of the proceeds, but I cannot get the goods back from the buyer. That's a risk I take about the honesty of the gallery there. This situation with securities in Article 8 is a little bit similar. The securities intermediary is not permitted to use a customer's securities as collateral for its own debts. That would be a criminal act. It is, however, permitted to use them as security for the customer's borrowing. So when the customer wants to have a margin account, then it is permitted to use them as collateral. And the rules that this legislation would change would undermine that. And so when you open up a margin account, you are presumably, because assuming you know what you're doing, you are authorizing your own securities to be used as collateral. And if you change this rule, no one will accept that collateral if there's any chance that a Tennessee resident is at issue in the transaction.
Thank you, Representative Garrett. That,
One more final, sorry, Mr.
You're
Chairman, is that all right?
recognized.
One
You're
more final to
recognized.
clarify that example. So in the art collection example, if the art dealer, for some reason, should go bankrupt or there's an issue while they're still holding, let's just say it was my art, which I can't paint at all. But if I did, and that happened, what protection for me in this art gallery scenario is there? Because it's my understanding in the securities world, there is insurance. There is a way to make that particular person whole. In the example you provided, is there protection for that if that should take place for me in an art gallery?
So if the art dealer in my example went bankrupt, it's still the customer's property, and if the property is still there, the artist will get it back. Unless the gallery has granted a security interest in this property, in which case the creditor might get the property and the artist might not get it back, and there is no insurance for that. In contrast, what you're dealing with in this legislation, there is insurance, federal insurance by the Security Investor Protection Corporation to protect the owner of the customers with the owning of the securities. So there is already in place far more protection, criminal law, audits, and insurance to protect the owners of securities than there are for, say, the owners of consigned goods.
Thank you very much. Mr. Chairman, thank you for your indulgence. I appreciate that.
thank you. Have Representative Balso, you're recognized.
Thank you, Mr. Chairman. Good afternoon, Professor Sepanek. It's a pleasure to have you here. I've got two questions. One concerns the choice of law issue that you raised, and the second involves the creation of the security interest. Dealing first with the choice of law issue, as we look at the UCC currently, we look at Article 8, is it accurate to say that the choice of law provision that's in play right now is one that allows the entitlement holder and the securities intermediary to agree as to the law of a particular jurisdiction to apply to their relationship?
The shorthand answer to that is yes.
And the shorthand answer is yes, because when we look at 47-8-110E, it sets out a series of agreements that a securities intermediary, such as a clearing corporation, might have with an entitlement holder, correct?
Correct.
And if we look at the proposal that's before us, it would eliminate those provisions of Article 8. That is, it would eliminate 47-8-110B and E and replace it with a new regime that says the local law of the entitlement holder's jurisdiction would govern. Is that correct?
That's my understanding of the legislation.
And that would be Tennessee typically here, correct?
Possibly. I mean, if you have a Tennessee broker and its customer is located in Canada, then it would be Canadian law. Go figure out what that is. I don't know.
Well, with regard to the bill, though, if it went into force, if it became law, do you have an opinion as to whether it would abrogate the existing choice of law provisions and agreements that Tennessee investors have with securities intermediaries?
Could you repeat your question? I want to make sure I get it right.
Sure. Right now, we've got thousands, probably millions of Tennessee investors who have account agreements with clearing corporations, other securities intermediaries that contain choice of law provisions.
Right.
Okay. If this body were to enact this bill that enacted a new choice of law provision, would that new provision abrogate the existing contractual choice of law provisions?
It might, and it might depend on where litigation occurs. So, for example, I personally have an account with Fidelity, which I believe is based in Massachusetts. Under existing rules, my relationship is, I suspect, governed by Massachusetts law, although I confess I do not know that for sure. If this legislation passed, Tennessee would be saying that it's governed by Tennessee law. But the other 49 states would still say it's governed by Massachusetts law. And so you would have to figure out, well, where are you litigating this issue? A court in Tennessee would apply Tennessee law. A court in any of the other 49 states would apply Massachusetts law.
Which would create a conflict.
Which would create a conflict.
And obviously, one thing that we always do here, we want to protect Tennessee investors as much as we possibly can, but we always have to comply with the Tennessee Constitution. And as you know, we've got in our Constitution a provision that prohibits impairment of contracts. It's Article 1, Section 20 of our state constitution. As you read the bill, would this new choice of law provision have the effect of perhaps violating Article 1, Section 20 of the Constitution?
I'm afraid that's beyond my area of expertise, so I would be very hesitant to make a point on that.
Let me go back within your area of expertise on the creation of security interests. My final question.
Okay, now you really are in my area of expertise.
Okay. When we look at 8-504B, and this is Article 8 in Tennessee, it states expressly that except to the extent that the securities intermediary and the entitlement holder otherwise agree, a securities intermediary may not grant any security interest in a financial asset. A financial asset, obviously, is a security. The underlying concern with this bill is that somehow securities intermediaries are creating security interests in financial assets without the agreement of the entitlement holders and to the detriment of the entitlement holder. My question for you, Professor, is this. Given that 8-504B explicitly provides that a securities intermediary may not grant a security interest except to the extent the entitlement holder agrees to it, how is this a problem?
I don't think it is a problem. I think this legislation is aimed at a non-problem. The securities intermediary is prohibited from doing what they're alleged to be doing and prohibited by the UCC. It would be a criminal act under federal law. There is no evidence that this is happening. I mean, Lehman Brothers failed. No customer lost money because of the rules that you're considering amending.
And the final question, Professor, is this. Obviously, the second part of the bill deals with the priority of security interests. But is it accurate to say that one does not get involved in determining priority of security interests unless first you have competing security interests?
That is correct.
And if a securities intermediary were prohibited from creating a security interest in a financial asset, then there would be no security interest about which a question about priority would raise.
If the securities intermediary is prevented from granting it, yes. If it's merely prohibited but nevertheless possible, you could potentially get the priority dispute. So I don't want to, I would love to be able to answer your question and say it can't happen. But I think it probably could happen, but it would take an awful lot. I mean, it would take a violation of the UCC, a violation of criminal law, would have to get past the auditors. There's no evidence that it actually does happen.
Great. Thank you very much. Thank you, Mr. Chairman.
Thank you. Chairman Grills.
Thank you, Mr. Chairman. And I know we have talked about this thing for weeks, and we've spent minutes upon minute. Can we go back into session, Mr. Chairman?
Without objection?
Okay. I will remove, withdraw.
Okay. All right, he's withdrawn his request. Okay, and Representative Gant, you recognize.
Thank you, Representative Grills, for backing up on that. Let me have a question. Thank you, Mr. Chairman. If we were to have a market collapse, your exchange with Representative Garrett, you were talking about insurance. What would be the maximum limit that Tennesseans are protected as an investor in the market if it were to collapse? What is that limit currently?
It's $500,000 per customer per account. So if you have a married couple, it's $1 million.
Okay. All right. Thank you. I think that's important to be part of the record, Mr. Chairman. Thank you.
Thank you, Representative Gant. Next up, I have Representative Powell.
Thank you, and thanks, Chairman Grills, for withdrawing, so I could ask a couple questions here. I'm on the front row here.
Thank you.
Sorry. A couple questions. One is, can you speak to, and obviously we want to protect Tennessee investors, but we also want to protect the options that Tennessee investors have. Do you think this could have a potential negative ramification on Tennesseans' ability to invest in these margin accounts?
Yes, and I think it's worse than that. I fear that not only would some intermediaries cease to do business with Tennesseans as customers, I fear that some more centralized intermediaries will cease to do business with other intermediaries that do business with Tennesseans because of the change in the rules. So, for example, DTC, which is the sort of centralized clearing agency, why would it want to do business with a intermediary in Tennessee that does business with Tennessee customers? Because now the whole structure of the system doesn't work right to protect DTC. So I fear you will actually really impair the ability of Tennesseans to participate in the global securities markets.
Representative Powell, you recognize, sir.
And would that apply to current accounts, or would basically all these intermediaries have to update their agreements, and then that could potentially have a chilling effect for already these accounts that exist?
Yes, it could.
Go ahead.
Just one more follow-up question. And could you speak to how this could impact these intermediaries? I know you've done this, but the impact that this could have on intermediaries that exist within Tennessee, and perhaps push those entities to have to conduct business outside of the state. Would this impact that as well?
Well, absolutely. I mean, it's not just the monkey wrench it throws into margin accounts, but it undermines the assurance that the centralized intermediaries will have in their rights vis-a-vis the Tennessee intermediary. So, as I said a moment ago, I would be very concerned that others will cease to do business with Tennessee intermediaries, which will then undermine anybody's ability to do business with Tennessee residents.
Representative Powell.
Sorry, stealing a page out of Representative Bolsa's. One final question here. Is there, I guess, an impact that you can foresee to those that have these accounts with this law being passed? I mean, have you seen in other, I guess, in other states, have you seen, because I know we're talking, multiple state laws, they try to conform, but have you seen another state have a change as drastic as this, or is this something else that other states are taking on, or would we be an outlier?
Oh, you would be an outlier. I cannot emphasize enough the importance of having uniform choice of law rules. When you start having different choice of law rules in different states, particularly with respect to Articles 8 and Articles 9 of the Uniform Commercial Code, then now all of a sudden where you litigate affects everything. And the whole system was based on making that not relevant. And so we want a system where parties from around the country, and indeed around the world, can contract with each other knowing what the rules are going to be, without having to investigate the laws of 50 states, plus the territories, plus potentially other countries. Now all of a sudden, oh, that wouldn't be the case. So the example I gave a moment ago about a Tennessee intermediary with a Canadian customer, well, under this rule, Canadian law would apply. And so who in the system wants to now start investigating Canadian law or Mexican law or wherever they want to do business? So it throws a huge monkey wrench into the way in which business is designed to operate efficiently and economically.
Thank you. Hey, and next let's have Representative Parkinson. Do you have a couple questions?
Thank you, Mr. Chair, and thank you too for the information that you're giving us. I'm trying to figure out how we got to such contrasting interpretations of what's happening here. I mean, you gave us information that completely, I mean, completely opposite ends of the spectrum of the information that we received last week, last week on this bill. And so, based on what you've told us that, you know, this the scenario that was painted for us last week, you know, the consumer is completely protected, and you know, well, based on last week, the consumer is not protected.
Right.
But based on your testimony today, the consumer is and has been protected. How do we have such a large gap in where we are on this?
I wish I knew the answer to that. There are a lot of people who, I'm assuming the proponents of this legislation are well-intentioned. I'm assuming they really believe what they have to say. Sometimes convincing someone that they're mistaken is very difficult. People hold on to their beliefs. I would love to be able to sit down with the proponents and try to convince them that they are mistaken. But you know, there are a lot of people who believe things that are wrong, right? There are people who would believe we'd never landed on the moon.
Yeah. Well, Mr. Chair.
Representative Parkinson, you recognize.
Thank you. Well, you know what they're here. You know, so you know, if you want to speak to them, I'm sure you know they'd be open to it. But Mr. Chair, I want to know are the guests that we had on that spoke last week, are they on the list today?
They are on the list today.
Can we stay out of session for a few more minutes to hear from them? Because I do want to understand why we got two totally different ideas of what, you know, what this bill is doing. Do you mind, Mr.
Well,
Chair?
Representative Parkinson, I'm at the will of this committee, and also I'll remind you, you sat through two subcommittee meetings with those same guests, having the hours of opportunities to ask them questions. But I'm at the will of the committee. Next on the list, I have
Mr. Chair,
Lady Lambert, you recognize.
Well, Mr. Chairman, I was going to make a motion for us to come back into session. I too have heard from both sides, but I'm not going to make a motion at this time. I mean, Mr. Chairman, it's up to you and the committee. I mean, Representative Parkinson has put it out there for the other side to come up and speak. We've heard quite a bit on this, but until that offer was tendered, I was going to make a motion for us to go back into session and actually debate and or vote on the bill, but I will not do so at this juncture.
Next, let's have Representative Capley, you recognize. Oh, you want to continue?
I had a question.
Go ahead. Go ahead. Representative Parkinson, you recognize.
Thank you, Mr. Chair. And I understand your point. However, we hadn't had a chance to have both of them in the room at the same time too, because I really think it's important that now, and I'm not accusing of anybody of lying, but there's no way possible for us to be so far apart on this issue and without, you know, something being able to be backed up by law or rule under the UCC to be able to give us the clarity that we need in regards to this legislation. That's why I was asking, you know, just to you know, ask, you know, how we got to these opinions that are so far apart. That's all, Mr. Chair.
I'm at the will of the committee. Okay, all right. Next on the list, I have Representative Capley. Me too. See here? All right, that distinguishes the list. Members, any more questions for our guests that we have in front of us now? Seeing none. Gentlemen, thank you so much for being here.
Thank you,
I
Mr.
appreciate it. Next on the list, I have, I had Ms. Hazlitt and Langford, so they're waving us off. Ladies, thank you. And then I have Mr. Webb and Grande are here as well. Representative Parks, that's not how the process works. You know it. They're up here. You can ask them questions for a third time now. Gentlemen, if you go ahead and please introduce yourselves for the record, for the committee. You're going to have 3 minutes between the two of you because you're from the same place and same. You all been here, and most of the committee's heard from you before. And we'll have unlimited times for questions. So you're both either one's recognized. Just introduce yourselves to the committee, and we'll go from there. Thank you.
My name's Don Grant. My name's Don Grandy. I'm a private practice attorney here representing True North Policy Consultants.
My name is David Webb, and I'm representing myself as a citizen.
And appreciate you guys being here. Spoke to you all both, like in committee, out of committee. So I'll just go ahead. Either one of you want to go ahead and just give your comments?
I'll jump in. I think I need to expose that this is a real problem and how we know that. I have written rebuttals to the letters sent by Andy Guggenheim. You should have that, the SIFMA letter. I've written a rebuttal to the testimony that was given last Wednesday. And a central part of that is exposing the response of the Federal Reserve, the New York Bank of New York Central or Federal Reserve Bank, to a questionnaire from the EU. And this makes it clear that pooled securities are vulnerable to secured creditors of the intermediary. We also see this in the code itself, that this is the issue, that the exposure is created by the intermediary. This is not this is not a debt of the client. It is a debt of the intermediary. So that is a very important document, and you have excerpts from that. Further, I'd like to say, to expose what is happening here, there's a Bank for International Settlements document titled Developments in Collateral Management Services. This is from 2014. It explains so this has been going on for more than a decade in a big way, and what you see is the flow of collateral in this chart. You see it flows from collateral givers to collateral takers. The collateral givers are equity desks, custodians. This is done on a global basis, and there is an automated collateral management system that operates particularly in a crisis atmosphere when the value of the collateral is falling, to sweep more collateral to the collateral takers. Now, who are the collateral takers? These are the central clearing counterparties where the derivatives complex is cleared. The issues here have been conflated.
Thank you, sir. If you could just, that's 3 minutes right there, and I appreciate that presentation. Next on the list, I have Leader Lambert. You're recognized.
Thank you very much, sir. We just make sure, give you a chance to give a rebuttal there, but with that, I make a motion that we go back into session.
Thank you, Mr. Any objections? Seeing none. We're back into session. Representative Bosso, you're recognized.
Thank you, Mr. Chairman. I move that we send HB 2806 to summer study, given the complexity of the issues.
Okay. That's proper motion, proper second. Members, all those in favor of sending House Bill 2806 as amended to summer study, say aye. Aye. Opposed, say no. Ayes have it. Thank you.